Lots of talk, most of it on social media, about a new Texas law set to take effect September 1st. That's this Friday. It specifically addresses insurance claims made for storm damage. While some say House Bill 1774 is good news for consumers, others argue it will significantly limit their rights, and they better act fast to avoid it. Our panel shares a friendship and a profession, but not the same opinion. Mark Ticer and Steve Badger are both Dallas-based attorney. Mark in studio on behalf of those who are policyholders. Steve on behalf of the insurance companies joining us via Skype. Now, gentlemen, before we get started, the one thing I think we can all agree on here is that this does not include or affect the National Flood Insurance Program through FEMA. That isn't subject to state regulations. We can agree on that?
Yes.
All right, Steve, let's start with you, Steve. You say as far as just filing a claim, come Friday, nothing changes.
Yeah, so let's be clear about the current crisis that has been all across social media. The only issue that is affected by whether a claim is filed by Friday is the interest rate that one would recover from the insurance company in the very rare situation that the claim is not amicably resolved, that there has to be a lawsuit, and that lawsuit goes to trial.
All right, Mark,
so
you say not so.
Well, my friend Mr. Badger, once again, is incorrect. It does a lot of different things. First of all, it limits the remedies that you would be entitled to under the current law. It lowers the interest rate, Steve's correct, from 18% to 10%. That could be rather significant. Second of all, you have more onerous reporting requirements that you've never had before. Third, you can limit the people that you can sue. In this case, the claims person that's handling the claim is personally responsible under the current law. Under the new law, they would not be personally responsible if the insurance company decides that they're going to assume the liability for them.
Mark, I want to back you up for just a second here, because hopefully we never get to the lawsuit phase, but you did mention and again, we've got a lot of people affected by Harvey. As far as the actual claims process, the very beginning stages of filing a claim, you just said, hey, there are some things that change about the way that you have to file that claim, some of the kind of burden of proof. What specifically are you referring to?
Well, you have to, if you file the claim before September 1st, you're going to be under the old law, and it affects the remedies that a policyholder would have, ultimately, whether there's a lawsuit or not.
Steve, we see the headlines again, especially on social media, the kind of this rush to, hey, make sure you beat the deadline just to file a claim. You say that that's not necessary.
No, Mark is perpetuating the same misinformation that's in social media. All of these other issues about House Bill 1774, whether you can sue an adjuster, whether you can get attorney's fees, those are all affected by when you file the lawsuit. Now, we just had a hurricane, so there's no lawsuit to be filed yet. The only issue that is impacted by when the actual insurance claim is filed is whether you get 18% interest if the case ultimately ends up being disputed, or 10%. That's the only issue that is relevant to this question of filing your claim by Friday. Nothing's different for the person who files their claim after September 1st than the person who files their claim before September 1st. Nothing is different in the claims process, or really the litigation process, because that's going to be dictated by when the lawsuit is filed. And everyone's going to be filing these lawsuits after September 1st.
Right. Certainly we're not going to see any Harvey lawsuits between now and Friday. You did mention, though, that notification. The new law does require somebody to say to the insurance company 60 days in advance, hey, we plan to sue you. Here's what we will sue you for, and here's what the attorney's fees are going to look like. Now, to the untrained eye, that sounds like a great idea, that this perhaps may get settled out of court. It may have an easier resolution to it. The two of you don't agree on that point, though.
I wouldn't agree. Well, it's a whole sea of change from the insurance law. There's nothing good about this for the consumer. It is all driven to protect and benefit the insurance company. Why else would you do this? Why would? Oh, can I finish, Donald Trump of insurance? Thanks. Look, it's real easy. The law was 18%. There was no notice requirements for a breach of contract claim. You could sue all the responsible parties, and now they've taken away purposely those rights on the imagination that this will curb claims, but all it does is benefit the insurance company and punishes the consumer.
I do think that we're getting ahead of ourselves here for a second, because we're talking a lot about this 10 and 18%, and I know most of our viewers probably have no idea what that's in reference to. So to clear this up, we are talking about the penalty that insurance companies have to pay if you file a claim, and if it is not, let's say, enough, and you decide to sue, and you go to court, and you win, and you get a judgment, then the penalty for the insurance company is currently 18% of whatever that difference was for the judgment. That is now going to go down to 10 for the moment. It's actually capped at 20. It's really based on a market rate. Steve, you say that
well, wait a minute. You mischaracterized how that works. You do not have to sue to collect. There are plenty of carriers that will pay the penalty pre-suit.
All right, Steve Badger, what say you?
Well, there's no liability under the statute until there is a determination by a court after a lawsuit and trial of a violation of the prompt payment statute. So if a carrier recognizes it makes a mistake and it chooses to make such a payment, Mark's right. That does happen sometimes, and carriers will step up when they recognize they make a mistake. But we're missing a lot of the points here because really what's important here with the legislation is that Texas has a crisis. The Texas Department of Insurance has reported a 1,400% increase in the number of lawsuits after weather-related events. That has created an availability and affordability crisis for insurance in Texas. Insurance companies are raising premiums, they're raising deductibles, and in some markets they were entirely pulling out because of the number of lawsuits they were receiving. And that's happening because of plaintiff lawyers who go door to door after claims are amicably resolved, and they rustle up through their case runners, they rustle up lawsuits that they try to pursue against the insurance companies with promises of free money. And my good friend Mr. Tyser knows that's a problem because he filed a class action lawsuit against some San Antonio lawyers for illegal civil barratry. And this is the problem we have in Texas. And all of this social media you're seeing right now is all being driven by those lawyers who are telling people, hey, you know, I'm the guy, I'm the Hale guy, or I'm the Harvey guy, and I'm going to help you with your claim. So make sure you file your claim by September 1. Oh, and then, by the way, hire me.
Right.
So
Mark, you of course agree that there are some bad apples here, but you say this kind of overreaches, this penalizes everybody.
Well, sure it does, and the statute change doesn't curb the abuse that he describes there. And I go after any lawyer that I can find that if a client approaches me and I think they have a meritorious case, I have no problem going after and holding lawyers accountable. But this urban legend of what Mr. Badger talks about is not borne out by any facts other than that's the mantra. Why would you penalize consumers for the conduct of some bad lawyers? Look at what we've had in this state and around here. We've had the tornadoes, we've had the hailstorms, we've now got Harvey and all these things. I can understand why litigation would have gone up. It's certainly understandable, but the other thing, could it just be that the insurance companies have decided they just don't want to pay and they're going to market or they're going to use this thing, delay, deny, and defend? Mr. Badger knows that's the mantra of many, many insurance companies. But the statute doesn't address the abuses of the lawyers, which they ought to be punished. It punishes legitimate claims.
Your remedies are not limited. The person with a $10,000 claim can still pursue every single remedy under the law. They can still recover their attorney's fees. They can still recover statutory interest, albeit somewhat reduced. They have every single remedy. All the bill does is require the lawyer to give us notice and say, hey, Mr. Insurance Company, you didn't pay enough. And we get notice, we get told what we did wrong now, and we have an opportunity to try to work it out with the insured, and that's good for everyone.
Hardly. It's a joke. what you went for and what the insurance company wanted was that bill, so they didn't have to pay as much. You want to go after the lawyers. Let's just impose the penalties on the lawyers. Let's hold them accountable. They should be held to a high standard.
Mark. We have. If a excessive demand is made, if someone makes a crazy high demand in their initial pre-suit notice to us, and then they go to trial, let's say they make a demand for $50,000 for the roof, the fence, the windows, the trampoline, the AC unit, and the bricks, and that's what we get now. We get $50,000 demands. Then they go to trial, and they only recover the $8,000 roof. And that's all they get. And the jury said, you know what, the roof was really damaged, and the insurance company should have paid. That homeowner still gets their $8,000. They still get their interest, but the lawyer who submitted the excessive demand, he loses his attorney's fees because he had an excessive demand, but the insured, the homeowner, still gets paid.
So we punish the consumer. I get it. We punish the consumer. If you can't prove your case, let's go after the consumer. I get it, Steve. The rates of insurance haven't gone down in this state. They continue to go up. We got to stop this foolishness. Your example you used was the lawyer, and then, oh, by the way, the insured, he gets his money. No, that's not how it works.
Speaking of the lawyer, gentlemen, both of you are obviously opposing counsel when it comes to this kind of litigation.
Sure.
So I do want to give you, in the moments that we have remaining, one opportunity to ask each other one question. I am sure that you feel like each other is certainly miscategorizing something. Mark, you go first. What do you have for Steve?
Steve, are you going to tell the people that are listening to this show that the statute is to curb frivolous or non-meritorious or claims or bogus claims? Is that what you're going to tell the people when all you've done is limit the remedies that belong to the homeowner, not to the lawyer?
All right, Steve, 60 seconds.
I'm going to tell homeowners and building owners in Texas that this legislation is designed to protect them from an affordability and availability crisis of insurance availability in Texas. Because if nothing was done, the private insurance market could not continue to absorb the enormous cost of litigation because of lawyers trolling around the state and signing people up for frivolous lawsuits. There is nothing in the legislation that takes away any remedies. Mark can still sue my clients for common law bad faith, DTPA, insurance code, everything he wants, every cause of action is there. But what he can't do is provide an excessive demand because then his attorney's fees are at risk. And Mark's a good enough lawyer to know that he doesn't want to risk his attorney's fees.
All right, Steve, your question for Mark?
Mark, are we going to make any progress on your lawsuit against the bad lawyers who have committed barratry that exists in Texas?
And I'm glad you asked me that, Steve, because here's exactly what I would say to that. One thing they could certainly help me on is saying that arbitration clauses in attorney fee contracts should be outlawed and certainly be outlawed in a barratry case when that's what they're using is to stonewall. It's not enforceable, but we still have to jump through the hoops. But if you could get that done for me, I would be enormously grateful.
All right, gentlemen, we thank you both for getting it done for us today. Amazingly enough, if Hurricane Harvey never came ashore, we probably would never even be having this conversation. This would quietly become law on Friday. No one would even know that it happened. Mark Tyser and Steve Badger, we appreciate your insight. You can read all about the new law, HB 1774, in its entirety right now. The link, fox4news.com. And of course, when you follow me online, facebook.com/SaveMeSteve.